Good afternoon, everybody. Thank you for logging on. Welcome to today's seminar. I'm Morgain Patterson, Director of Municipal Law and Training with the Kentucky League of Cities, and I'm going to be presenting today. Before we get started with the webinar, I want to go over a few housekeeping items. First, if you have any technical difficulties with audio or visual issues, please use the chat feature and select Send to all panelists so our training and administrative associate can assist you. Also, keep in mind that this webinar will be available to you on a rebroadcast basis starting tomorrow and will be available for up to 2 weeks. We will send out an email with the link to all registered participants, so if there are any technical issues, you will still have access to the content for 2 weeks. If you have any questions for me regarding the content of the webinar, please use the Q&A feature and not the chat feature. We have around 20 participants registered for today's webinar, so I'm likely going to hold questions until the end. That way we can get through all the content within the hour, but I'm going to take the time to make sure we can respond to all the questions. Also note that periodically we're going to have random polling questions throughout the webinar. In answering these polling questions, it ensures that you receive training credit for the registered user. Lastly, please be aware that we have a discrimination and harassment in the workplace webinar scheduled for March 24, and we plan to have other various topics in months to follow. You can always register for any upcoming webinars at klc.org. If you have any specific requests for topics, please feel free to let us know. Okay, now that we have kind of given you guys the that version, we're going to go ahead and start our webinar. Okay, so what are we talking about? We are talking about cannabidiol use and workplace drug testing. I know it sounds like a great big mouthful. Cannabidiol, what I'm referring to, is essentially CBD oil. I know a lot of people have found it helpful. If you have any questions about people who would find it helpful, just ask around. I know it takes me about 3 questions in before somebody in a group, whether we're at dinner or whether we're hanging out at work, for somebody to say, yeah, I use that, it helped me quite a bit, or my mom had some knee pain and it was very helpful for her. It seems to be a remedy that is useful for a lot of people. The problem is what happens when people who are subject to workplace drug testing use cannabidiol. And that's what we're here to discuss today. The problem starts with this. In these pictures, you have pictures of both hemp, which is part of the industrial hemp program here in the Commonwealth of Kentucky. So some of this is legal and some of it's not. Some of it's marijuana. Can you tell the difference? And of course you can't. What I'll tell you is for each picture, there is a corresponding picture of the other plant. So for example, in the bottom left, I believe this is hemp. Don't hold me to that. In the upper right, that's marijuana. And the same goes for the budded plants. One of these is hemp and one of these is marijuana. I'm sure a biologist or a botanist could tell you the difference, but I cannot. And again, even with refined products, we're talking about very similar looking products. We have CBD gummies, we have marijuana gummies, we have CBD oil, we have marijuana oil, we have things that look like vitamins that are both with cannabidiol made with hemp or THC made with marijuana. So you can see that at first blush, it's difficult to impossible to determine what is made with hemp and what's made with marijuana. So, first quiz, first poll. All right, pop quiz. Can smoking hemp, industrial hemp, result in intoxication? I'm going to launch your poll here. You'll have a few minutes to vote. So if you want credit, we'll need you to go ahead and vote. Okay, I think everybody who is interested in voting has voted. So 74% of you said that smoking hemp cannot result in intoxication, and 26% of you said it can. The 26% is correct. Smoking hemp can result in intoxication. It's a common misperception that hemp does not contain enough of intoxicating chemicals to result in intoxication, and that's simply not true. What we have recognized in industrial hemp in the Commonwealth of Kentucky is that there are some legitimate and significant benefits to growing this, and that there are mechanisms for growing and for manufacturing or producing various consumer products that minimize exposure to the intoxicating chemicals in hemp. So that tells you in and of itself the huge problem when it comes to some of our employees using various products that are made from industrial hemp and may or may not be regulated, which we're going to get into. So what is CBD? CBD is cannabidiol. That's what CBD oil is. It's one of 87 chemicals. Now, some research says 114 chemicals, but I didn't really want to get into that. I'm not a scientist. I read the literature and put things up here. They're called cannabinoids, and they're found in the cannabis plant. CBD is found in both hemp and in marijuana, which are strains of the same basic plant. They're both cannabis plants. So what this means is that in the Commonwealth of Kentucky, only CBD that's extracted from industrial hemp, or this will soon simply be called hemp, that is grown under the Kentucky Proud label are actually legal in Kentucky. Now, why is that? Because to be sold in the Commonwealth of Kentucky, these products have to be below a THC content of 0.03%. So this means that they have to be tested, right? And only those products labeled Kentucky Proud or that are federally regulated have been government tested in any manner. The concern comes in that there are a lot of CBD products on the market. There are a lot of products that promise a range of health benefits. Anything from pain relief to dietary relief. There are all sorts of potential benefits. None of them have been approved or recognized by the Food and Drug Administration, and they're not tested. So what happens is that there are unregulated, untested products out there. In a 2017 study from the Journal of the American Medical Association, they did a very unscientific test where they simply ordered a bunch of CBD oil off the internet and they tested it. 21.43% of the sampled CBD products found online contain THC levels high enough to cause intoxication and that would result in a positive drug test. They also found that 26% of the products tested had either a lesser percentage of CBD than advertised or had no CBD at all. So this means that not only are there illegal products available for purchase, but it is a buyer beware market out there anytime you're going to step outside of a federally regulated or a Kentucky proud item. So what are we talking about when we're talking about THC? THC is tetrahydrocannabinol, and it's taken me a while to figure out how to say that flipping word. Don't make me say it a whole lot. Anyway, it's another one of the chemicals found in the cannabis plant. It's called a cannabinoid, and it does have psychoactive properties. There are other chemicals in both hemp and marijuana that have psychoactive properties, but THC is the primary culprit, and it's the one for which urine tests are looking. So it's found in both marijuana and hemp, and it is not legal in the Commonwealth of Kentucky, right? Unless it's part of the industrial hemp program and the amount is below 0.03% THC. A common misconception is that CBD products don't contain any THC, and that's simply not the case. It's an unfortunate reality that even some CBD products that are labeled 0 THC may contain THC. It's unfortunate that it's not regulated, and it has led to a number of employees all across the country losing their jobs. Only those products that have been verified by the Kentucky Department of Agriculture or that are federally regulated are guaranteed to have come from a legal source. So what that means is that in the Commonwealth of Kentucky, if a farmer is participating in the hemp program and they're growing Kentucky Proud products, they have batches that are defined by regulation as to what those batches are. And if they are going to use the hemp for a consumer-related product or for secondary sale, what have you, what they're going to do is they're going to take it to the Department of Agriculture or to another certified and approved tester, and they're going to have each individual batch tested for THC, and it has to test below the 0.03%, or the hemp has to be destroyed. And I saw an article just the other day when I was preparing for this that hemp farmers across the country are struggling with keeping the THC levels below and the 0.03%, and they're worried about having to destroy a significant amount of crop after they've spent all the money to grow and harvest. It's a pretty significant problem. So hemp and the law. I know you guys are excited. We get to the legal part. KRS 260-850 subsection 6 defines industrial hemp as the plant cannabis sativa L and any part of the plant with a THC content of less than 0.03% on a dry weight basis. And again, the dry weight basis, that's what we were talking about, where they pretty much take it from the field and then take it to be tested, and they have the batch testing. Here is where it gets confusing. KRS 218A-010, subsection 28, that's where we get the definition of marijuana. And we're going to deal in double negatives here, so you can read what it says, and then I'm going to tell you what it says. Because if you're like me, if somebody says, do not do that, it's very confusing, and that's essentially what this statute says. Marijuana does not include, and then it goes on to say, it doesn't include any living plant, viable seeds, leaf materials, or floral materials. So what the statute is trying to say is that marijuana does include hemp that is a living plant, a viable seed, leaf, or floral materials. The reason this is important is we had a city where an individual was smoking what he called a CBD flower. Well, I'd never heard of CBD flower before, Didn't really know what that was. So when I looked it up, it looks like a hemp bud because there's no such thing as a CBD flower. It is the bud, the flower of the hemp plant. And it's not legal to sell, to possess, to use in any way, shape, or form in the Commonwealth of Kentucky. It's still classified as marijuana. It is still an illegal product. What had happened is that there were some people from out of state who were selling these as pain relievers, what have you, and some good faith retailers. No one had any reason to believe that these retailers were trying to sell, an illegal product. They had purchased it, believing it was legal, and they were reselling it. The other reason we're pretty sure it was a good faith purchaser is they were doing it at a gas station on a main state highway. They were not hiding it. It was in a glass case. So we worked with the Kentucky Retailers Association, and we tried to get the information out there on what is and is not legal to sell. Okay. The problem for this particular employee is that they had a CDL, and the CDL was required for employment. So stay tuned on that. We're going to talk a little bit more about it. But this is the problem with the lack of education about both hemp, cannabidiol, marijuana, THC, and the like, is that this type of confusion and this reliance on the fact that because it's on a shelf, it's okay to buy, has led to some people losing their jobs and or being in jeopardy of losing their job. And under KRS 260-858 subsection 3, it's unlawful for anybody who doesn't hold a license issued by the Kentucky Department of Agriculture, that's the department they're talking about, or who is not an agent of a licensee to cultivate, handle, process, or market living industrial hemp plants or viable seeds, leaf materials, or floral materials derived from industrial hemp. So again, a big mouthful, another section of the statute where they're reiterating, look, you either have this license, you're part of this regulated hemp program, or you can't have any of this. So it's important that we as employers educate our employees about what can and cannot be used. Okay, I actually go to a massage therapist who advertises that she uses CBD oil, and I don't even risk it. I just tell her, no, thank you. Please do not put CBD oil near me, around me, on me, anywhere near me, But a lot of people, it seems to help. Okay, so boiling it down, what's the deal? Legal CBD products purchased from companies participating in the Kentucky Proud program, okay, or manufactured by companies participating in the Kentucky Proud program. You can find that Kentucky Proud label. And then I mentioned federally regulated products. The only federally recognized CBD product is Epidiolex, and it is a federally regulated prescription medication for seizures. The federal government and the Food and Drug Administration does not recognize CBD as a medicine or a treatment for use or consumption in that fashion by any other any other product. So when I say a federally regulated product, I essentially mean a prescription medication or nothing. So when you see these CBD products being sold across the country, the Food and Drug Administration treats them similarly to other types of health supplements. It's not regulated, it's not tested by the federal government, and their regulatory role at this point is to determine and to react when they've been notified that a product is promising health benefits or other benefits that have not been recognized by the FDA. And they've sent out 20 some odd letters to various companies explaining that they have to put these promises, or they have to take these promises off of their advertising materials. They're not testing, they're not doing anything else. So What is illegal? Any CBD product that contains more than 0.03% THC, any product containing plant matter, stems, leaves, flowers, or other parts of industrial hemp, and marijuana. Okay, pop quiz. Are CBD flowers legal to sell and use? Okay, hopefully you all get this one right. If you don't, that's okay. There's no shame. Okay, I'm going to end polling. And congratulations, everybody got it right. You are listening to me. Okay. So this begs the question, why can these untested products be sold on the market? The reason is, and this may surprise you, but government is not flexible enough to respond to consumer demand. These products they began manufacturing them. States are on the front end of legalizing them, of legalizing medicinal marijuana or even recreational marijuana. Federal government still doesn't recognize any of this. They don't recognize any medical purpose or use for marijuana or for cannabidiol, the CBD oil. They've gone through testing, but as you can imagine, that takes a long, long time. So they just don't have the science to back up a lot of these claims, which means there's no way to know whether the CBD oil or other refined products contain THC. And to determine whether they do, it requires a lot of expensive testing. There's a Forbes article that I read that kind of gave you some figures. Some labs are as inexpensive as $100 per sample. And I know that sounds really expensive, but others are really, really expensive. But this is on the open market and not government testing facilities. And one of the things that the Forbes article addresses is that if you are, let's say that I'm in the CBD business, and I know that maybe there's been some cross-pollination and my hemp is going to be a little higher of a THC content, I may know where to go to have a lab that might not be as scrupulous as others. And I know that may shock you that this exists, but it's true. And, if I know that, and I know that maybe they're not quite as careful about the numbers of interpreting the test results and the like, and I think I might have a problem with my product, well, instead of risking having to have my product destroyed and not make it onto the open market and get my money back, that's where I'm going to go. So that appears to be happening. The other issue is that equipment to test THC levels generally cost around $600,000 per piece of equipment. Even in the Commonwealth of Kentucky, I believe the Department of Agriculture has one. The Kentucky State Police has several. And I believe there's one other entity that has one, but not many, because they're expensive to purchase, they're expensive to run, they're expensive to keep up. And if you think about just in the Commonwealth of Kentucky and how much of this product we're producing, consider how expensive it would be for the FDA to have to regulate every CBD product sold in the United States. It would just get to be cost prohibitive. So that's another reason why the testing is maybe a little slower on the uptick than we would all prefer. But my employees might take this. That's a problem, because again, I've heard time and time again that it's very helpful to people. Employees should be trained on your drug and alcohol policy. You're going to have to pause for a commercial. KLC, we have certified city, or not certified city of ethics. We have the certified drug-free workplace training. We can help you with legally compliant drug testing policies. And Andrea and Courtney would love to help you. Our drug testing policies include a notification to all employees about CBD, just to make sure that they are aware that taking CBD oil can result in a positive drug test. It's important that they understand the ramifications of whatever they're ingesting. If you have employees with CDLs or safety sensitive employees, they need to be aware of the potential consequences for a positive drug test. Any federally regulated employees are going to have serious issues with the positive drug test, and we're going to get into more of that here in a little while. For CDLs, they have to be removed from service. We're going to talk about that. And there are different testing standards for different classes of employees. So it's important that employees know, what's my job? When can I be tested? What are the ramifications? Am I going to lose my job? Does my city have a zero tolerance policy? What's going to happen here? So with the varying drug policies, employers with a zero tolerance policy, they should terminate if an employee has a positive drug test. That's not me being mean, vindictive, nasty. Oh, Morgan hates CBD and she doesn't want people to, have relief from the creaky knees. That's not it. Zero tolerance means zero tolerance. You either have it or you don't. If you have a zero tolerance policy, but you make exceptions, then that's a bigger problem than simply not having the zero tolerance policy to begin with. Okay, so if you don't want to terminate people when they test positive for drugs and alcohol, then you need to take a look at your personnel policy. Okay. If an employer chooses to adopt a policy allowing employees to retest, then it must apply the policy equally to all employees and include follow-up testing to ensure compliance. What does that mean? Well, some employers will, first off, the urine tests will be submitted to a medical review officer. That medical review officer is going to look at the tests and determine whether there's a medically legitimate reason for the person to have tested positive for a prohibited substance. I'm going to go ahead and kill your joy now. Using CBD is not a medically valid purpose for testing positive for marijuana. So unfortunately, that's not a way around it. But one of the things that some employers do is give a person an opportunity to seek EAP, to go through some type of counseling and or drug treatment and retest. If that's the case, then it has to be applied the same to every employee, and it has to include follow-up testing to ensure compliance. Additionally, it's important to keep any Americans with Disabilities Act issues in mind if an employee states that they're an alcoholic or drug addict. Those are recognized diseases, recognized disabilities under the Americans with Disabilities Act. Now, this doesn't mean that if someone tests positive for a prohibited substance or for alcohol, that there are automatically ADA implications. That's just not the case. However, if, let's say, you have a CDL driver who has been selected for the random drug screen, and they come in and tell you, I'm a drug addict, and I'm really struggling, and I'm using this prohibited substance. That's when there's going to be an issue with the Americans with Disabilities Act from the perspective of they've used triggering language, and HR needs to be notified immediately. Your city attorney needs to be notified so that you can go ahead and go through accommodation analysis and figure out what needs to be done. That's beyond the scope of this particular webinar. And it's also a very fact-specific situation. So I'm making it as cut and dry as I can, but even there, you don't want to rely simply upon what I'm telling you in this webinar to decide that someone needs to go through ADA analysis to determine whether the city needs to accommodate them. That's something you really need to work through. It needs to be clear in your policy, and you're going to want to work with your city attorney on that and contact us if need be. So there are strict standards for federally regulated and safety sensitive employees. Now, the federally regulated, it's very clear. CDL is the most clearly defined zero tolerance. It's in the federal law, in the federal regulations. The others, there may be different standards for, but you can still have the zero tolerance or some type of standard that removes them for duty for other safety sensitive employees. Police, fire, EMT, telecommunicators, the dispatchers, dispatch supervisors, heavy equipment operators, and this includes sanitation trucks. Anybody who operates, repairs, or maintains passenger carrying vehicles, lifeguards, gas pipeline workers, if they actively work on the pipeline, or if they respond to emergencies, anyone who oversees, anyone involved in watching children or transporting children, anyone involved in transporting the elderly or anybody with a disability. Those are the types of positions that we're talking about when we get into the safety sensitive positions. And it makes sense when we list them off, because these are people who could potentially do the most harm to the public if they are intoxicated or impaired in any way. Again, getting into each individual safety sensitive or federally related position is a little beyond the scope of what we're talking about today. And this is not a drug-free workplace seminar. So if you have any questions about anything of this nature, please get in touch with Andrea or Courtney or myself if anything comes up, and we will help you in any way we can. Okay. So, types of employment testing. I know I just told you it wasn't a drug-free workplace seminar, and then I go into types of drug-free testing. We're still going to kind of skip over or touch the surface, dip our toe in here. The types of employment testing, we have pre-employment testing. That's when you require this type of testing for hire. Random, safety sensitive, and federally regulated employees only. You cannot, as a government employer, randomly drug test all your employees. Oh, and while we're mentioning that, you can't just say, hey, I'm the city of Kentucky League of Cities, and we're going to designate all of our employees as safety sensitive. I know, it's been tried, it failed miserably, so saith the court. And we also have reasonable suspicion testing. This is based upon observations of the supervisor or employer that individual reasonably believes the employee is using alcohol or illicit substances while at work, at a work function, conference, etc. When you're talking about reasonable suspicion, you're going to want to have a case built there. This isn't just, well, their eyes were red, so we're going to send them for testing. There are criteria that we suggest that you follow. I wish that there were a bright line. I wish it were completely black and white. That's not the case. If you have any question as to whether you have enough evidence that a supervisor or an employer or someone observed that an employee might be intoxicated, give us a call. We'll help walk you through it. Talk to your city attorney. But you want to make sure that you have enough there. And then there's also post-accident testing. That's only when it's likely to be related to drugs or to alcohol or illicit substance use. The reason is, again, we're talking about a governmental entity. So, you know, post-accident testing, you're really going to have some articulable reason to suspect that it could be related to alcohol or illicit substance use. This doesn't mean that you smelled alcohol. It doesn't have to be that high of a burden, but just, you know, a stubbed toe isn't necessarily related to alcohol or illicit substance abuse, okay? So, another pop quiz. Can you subject administrative staff to random drug testing? Okay, I'm going to close the polling now. So the question is, can you subject administrative staff to random drug testing? 77% said no, and 23% said yes. 77% of you were listening. No, you cannot simply subject administrative staff to random drug testing unless somehow that administrative staff member, for example, has a CDL and you consider someone with a CDL who regularly uses the CDL in their day-to-day job as an administrative staff member. So basically, no. That is not going to be a safety-sensitive employee. That is not going to be somebody who's a federally regulated employee. And as a general rule, you cannot subject just administrative staff to the random drug testing. Lecture over. On to the next slide, I think. It's a common question. Why not all employees? We get so frustrated because why am I picking on my CDL employees, my federally regulated employees? Why can't I just test them all and subject them all to random drug testing? Well, that's because the courts say no. As a government employer, any action taken even as an employer must withstand Fourth Amendment scrutiny. And the Fourth Amendment is the prohibition against unreasonable searches and seizures. It balances the government interest with the employee's right to privacy and to be free from illegal search and seizure. You will hear us talk about that a lot. When you call and you say, I want the employee to submit to a medical test, I want the employee to submit to X, Y, or Z, we're going to say, what's your cause? I want the employee to submit to the random drug testing. What's your cause? Why? Courts are going to look at whether the government's employment interest is related to the need for testing. That's why there's the different standard for safety-sensitive employees and CDL employees. And that's why you don't drug test an employee who goes into anaphylactic shock at work due to a bee sting, even though it's an accident that occurred at work. As we stated previously, you're going to have some idea, some way to show that you cannot rule out drugs and alcohol for that accident before you do post-accident testing. Excuse me. So urine tests for marijuana. DOT employees must be sent for tests that are generally urine for drug tests. A positive urine test for marijuana is actually a positive test for the presence of marijuana metabolites. So that's whatever your body uses to process marijuana and get that, warm, fuzzy feeling people get from it. A positive urine test only means that THC is detected at an impermissible level. Does not necessarily mean that the employee is currently intoxicated. In fact, I think there is a pilot test that they say now can determine whether someone is intoxicated, but there is no commonly recognized method of doing so. THC, again, I say it over and over again because it's important. It's present in both hemp and marijuana. And unfortunately, there's also no test that determines the source of the THC. And so this means that employees have no defense if they have been ingesting what they believe to be an otherwise legal product and they inadvertently ingest an impermissible level of THC. There's just no defense to that. Okay, Kentucky Department of Transportation for CDL notifications. I took this, copied and pasted it from the Kentucky Department of Transportation's website. I did that because all CDL holders should be on notice. If you think that you have someone who's had a CDL forever and ever and ever, amen, who doesn't have it, send this to them. It very clearly lets CDL holders know that the Federal Motor Carrier Safety Act considers CBD to be a controlled substance. Okay, this means that it is an impermissible substance. And because it remains an unregulated drug, some CBD oils have as much of 1/10 of the THC concentration as marijuana. This means they're going to present with a positive drug test if they're randomly sampled. Okay. The Federal Motor Carrier Safety Act has a lot of information that relates to legalization of marijuana on their website. I didn't want to just cut and paste that, but it's important that any of your CDL employees know about this. And we're going to get into why this is such a big deal. Isn't she pretty? This is Cree. She's my dog. I've raised her from 5.5-month-old. She's a beautiful girl. Anytime I put shenanigans in a PowerPoint, you probably want to pay attention, aside from the fact that she's just pretty. Okay, so why is this so important? Because the federal government has a zero tolerance policy, and this is going to impact both employers and employees. If you have a CDL employee and that individual has been selected for random drug testing and they test positive for marijuana metabolites, what's going to happen is they're going to go in, they're going to take their drug screen. That's going to get sent to the medical review officer. Medical review officer is going to say, look, there's a positive test for marijuana metabolites. Your employee may say, hey, I was smoking a CBD flower, or I was using CBD oil on my knees because I have really bad knees or bad back or what have you. And the medical review officer is going to say, nope, that's not a medically recognized reason for using this product. I'm going to go ahead and you're going to test positive for using a prohibited substance. The employer has to report it. Okay, it even says right here in the federal regulation, as an employer, you may not disregard, you must not, even stronger than may, a verified positive Department of Transportation drug test result because the employee presents a negative test result from blood or urine specimen collected by the employee's physician, or a DNA test result purporting to question the identity of the DOT specimen. This was another question that we get. What if they come back with a test that shows that our urine test was wrong? Well, they can't. And the federal government has been very clear in this federal regulation that once the DOT test has been given and the medical review officer has given their results, the only process from that perspective is to remove that employee immediately from service, to offer them a SAP program, and to go forward from there, which we're going to talk more about it. It doesn't matter if they provide a DNA test result saying, wasn't me, or, the Nelly defense, or whatever they do. It's still not going to work. And there are significant penalties to both the employer and to the employee if it's allowed in violation of the federal regulation. Talks about what the employer's responsibilities are when there's a verified result. Once there's a verified result, they have to be immediately removed from performing any safety-sensitive functions. You have to take this action upon receiving the initial report of the verified positive test result. You can't wait to receive the written report or the result of a split specimen test, okay? You have to do it immediately. As soon as the verified report's received, they have to be removed from service. As an employer, when an employee has a verified positive, adulterated, or substituted test result, or has otherwise violated DOT agency drug and alcohol regulation, you cannot return them until or unless they complete a return to duty process. We're going to talk about what that is. So, and what do I mean by adulterated? Well, so let's say they dilute it. They dilute the urine, or there's some reason for the medical review officer to send you back a verified test result that says it's been adulterated or that it's been substituted. Maybe it's somebody else's urine or what have you. they catch these things. And as soon as that comes up, you're going to have to remove them from duty. Oh, this is the employee's responsibility, and it's going to talk about what you have to do when an employee has presented. So they have to go through a substance abuse professional evaluation. This is what you have to do. Okay, the SAP, there are regulated substance abuse professionals that are recognized by DOT for these purposes. The individual who is tested positive or had an adulterated or other result has to be sent for an evaluation. They're going to be referred, and there will be a treatment plan of some kind. Now, that treatment process may be that they just go to drug and alcohol counseling once a month. Or it can be they need to go to an intensive outpatient drug and alcohol treatment program. It's going to vary based upon what the SAP believes is necessary. So they go through the SAP evaluation. They have to complete whatever program the SAP puts in front of them to be able to return to work. Okay. So, as an employer, you're not required to pay for the SAP evaluation or provide it to them or any subsequent recommended education or treatment. Okay, you can pay for the extended drug and alcohol treatment. You can go through that, but you're not required to. But if you offer that employee an opportunity to return, you have to make sure that they've received the SAP evaluation and that they've completed the entire program and that they continue to comply with the SAP evaluation recommendations. This is going to include continued drug testing. This substance abuse professional will recommend continued testing for the employee. It'll be unannounced testing for no less than 6 times in the 12 months following the return to service, and they may prescribe up to 60 months of testing. And this is the important part. Any person who fails to follow the protocols and returns an employee to work gets a pretty heavy penalty. There's a hearing process for an appeal, but the civil penalty for the employer is up to $10,000 per violation, and the penalty for the employee, who is also subject to these fines, is up to $2,500 per violation. So there's a pretty heavy hammer with these. Now, what I did not go into, I went into the CDL regulations and focused on this simply because of the penalties to employers and how rigid this process is. There are other requirements for drug-free workplace. There are other requirements for people who work on the gas lines and the like. There may be separate requirements in your individual personnel policies. They want to go too far into that. If you have any questions, please contact Andrea, Courtney, or myself, and we'll help walk you through that. So pop quiz, you had to know this was coming. Who is the prettiest dog ever? You've seen the picture maybe? Remember, this is for credit. I'm going to give you a chance to change your answers now because somebody's sassy. Okay, I'm going to go ahead and end polling. Okay, somebody picked Scooby-Doo, a far inferior creature to my beloved little creepster. So whoever that is, I'm going to ask Soraya to fail them and they don't get credit. I'm just kidding. You get credit for answering. But most of you are smart and picked Cree. And I don't even know who said what, by the way. Okay. So as we were saying, what about other employees? Other safety sensitive employees must adhere to the standards established in the employer's individual policies. Law enforcement policies and other may be more strict depending upon the circumstances. And this is going to be because of this wonderful thing called a Brady disclosure. Any of you who deal with open records, or if there are any city attorneys on here, are going to be well aware of what Brady disclosures are. Essentially, anytime an officer is involved in a criminal case, you have to disclose any type of wrongdoing that they've ever committed, anything that could potentially impact the criminal case. It's important to keep in mind all other employees must be treated equally, and any precedent should be followed to avoid claims of discrimination. In the Commonwealth of Kentucky, everybody, as similarly situated employees, have to be treated similarly. So discrimination isn't just the federally prescribed reasons. It can also simply be treating similarly situated people differently. And then I am going to open this up for questions. Okay, you guys open your Q&A panel. If you have any questions, I can go ahead and answer them. We have come to the end of my presentation. I'm sure it's all clear as mud. It doesn't look like anybody has any questions, so I must have just been that good. Here we go. They asked if there's something we can share with employees, just kind of an FYI. So you can share any of this presentation with employees. Again, there's a lot of information on the Department of Transportation website, and we're gonna, if you want it, I can put something together for you. The question, are the at-home tests accurate? So I don't know whether the at-home tests are accurate. Honestly, they're not acceptable for the Department of Transportation regulations for certified drug-free workplace. There has to be a certain testing. And then, is there a KLC policy? Our policy, our drug-free workplace policy, and all of our personnel policies include this information already. And what we've done in response to this problem with CBD is we have included that language in our new drug-free workplace and our personnel policies. So if you have any questions about that language, please email Andrea and Courtney and they will help you. Then another question, if we send a DOT employee for random drug screen, does the facility have to give the results to the employer? They do have to give the results to the employer. And HIPAA doesn't impact that exchange of information because the federal law requires them to do it. Now, obviously, you can't release that medical information after the fact, but that's how the employer is capable of getting that information. Does anybody have any other questions? Going once, going twice. Who has Kentucky Proud products? I'm not for sure, Julie. I stay so far away from this stuff. I do believe that they sell the Kentucky Proud products at most grocery stores and at most drugstores. I know you can buy it online. That's where some people I'm aware of who use this in the law enforcement community purchase it. if you look on the Kentucky Department of Agriculture website, I think they have lists of vendors who have the Kentucky Proud products. So that may be a place for you to go. But you can find it, they all have that Kentucky Proud label. Do you have any other questions? Okay, well, if you think of anything after the fact, you have my email, you have my phone number, hopefully, and y'all just give me a call, email me if you think of something later, and we'll look at putting something together that you guys can give to employees, and I can email that to y'all. And I got a last minute question. So even if a Kentucky Proud, if you test positive, it's still a problem? Yes. It doesn't matter if you test positive, if there were some glitch in the Kentucky Proud product and an employee still tested positive, yep, it's still a positive drug test. There's no way for the test to determine the source of the THC that the marijuana metabolite responded to. So I appreciate y'all attending our webinar today. Again, please let me know if you have any questions, email, call, what have you. And hopefully I'll see you at the upcoming ACE conference in June. Stay tuned for more information about that and for our other training events coming up. Thank you so much. Y'all have a good one.